So this is a complex and what could be messy situation to be in, but I'm pretty sure it's common in the wind industry. And this is in response to a video I did earlier today, my last video, explaining how the Osage Nation here in Oklahoma just won a lawsuit and is getting a wind farm taken down on their property that was put up without the proper leases from the Osage Nation. The Osage Mineral Council owned, basically the tribe owned the mineral rights on the land, and someone else owned the surface rights. Osage Wind and Enel, E-N-E-L, Green Energy, got the surface rights, but they did not get the mineral rights. They didn't think they needed to. Now, first of all, as with this question, nobody owns the wind energy. Except for the wind company. So if you're a surface rights owner or a mineral rights owner, you don't own the wind energy, but you do get paid for use of your property. Now, in every state that I've ever worked in myself, the law has been the same. When you have one person or entity that owns the surface rights and a different person or entity owns the mineral rights, the rights tend to go to the mineral rights owner because they have as much right to access and enjoyment of their mineral rights as the surface owner. So the surface owner can't do anything to stop the enjoyment and use of the mineral owner's rights. In this particular case, the wind company dug deep into the ground, buried the transmission lines, dug however deep they had to dig to set up the structures, the wind turbines. And in addition to that, the wind farm itself could potentially cause a loss of use of enjoyment to the Osage tribe for their minerals. They have to have access to their minerals. Now, I don't know how this has worked on a case-by-case basis in the past, but based on this court ruling that found in favor of the Osage tribe, and this is what could make this court ruling huge, the wind farm must now obtain a lease of the mineral rights to put a wind farm on that land, in addition to the surface rights, the mineral rights as well. There are going to be instances where this will have a ripple effect. For instance, where they want to build wind farms in potential oil fields or existing oil fields. Those mineral rights will likely already be leased by an oil company. And those wind farm companies will have to get access to those mineral rights. They will have to get permission, which may involve putting up some money to build wind farms where they are on land that is rich in oil and gas. And oil and gas minerals are a lot more expensive than surface rights. A lot. So to answer your question, like I said, nobody owns the wind energy, but whoever owns the surface rights must be compensated for use of what they own, and whoever owns the mineral rights must be compensated as well. And if those mineral rights are worth a lot of money because it's in an area that is rich in oil and gas, there definitely could be instances in the future where potential wind farm builders have to pay out the nose for those mineral rights, so much so that they don't build the wind farm. Not to mention there are already existing wind farms on this type of land. There are already existing wind farms where those mineral rights leases are not in effect. So this could cause further lawsuits with different wind farms and different wind farm companies if they don't have the mineral rights or access to the minerals. It could alter the way wind farms are designed to allow for spacing for drilling rigs to come in and capture those minerals as well. I'm sure there are places where people are already doing this, but I am positive there are a lot where this has not been considered. So this ruling could have a huge impact on a lot of mineral owners and wind farm owners in the future and with existing farms. Yes, for sure. Thanks.